I'm understanding that we actually have the tape of the arraignment. Let's listen together.
Let's try our case first. So with respect to whatever goes on there, as the party with primary jurisdiction, the trial and the sentencing will take place here prior to anything that takes place in the federal system.
So that could be, what you just said, the answer is it's fine if we take custody today.
That I'm not sure, because Your Honor signed a writ in which it says that we're going to return the defendant to federal custody. So I think that would be step two. I do think that logically, as the party with primary jurisdiction, the custody should be here, but I asked the court, in light of the court signing the writ, indicating that we would return him to federal custody, that be done at a later time.
Well, I've been through this before, and if you do that, they will read him right out of here. So I don't think I'm going to do that. But if you work it out with them, that we can take custody rather than us bringing them back for any proceedings, that would be great.
We will make every effort to accomplish that, Your Honor.
But there should be some kind of detainment, and I know that.
Yes.
If there's securing order changes, there should be some mechanism that is going here.
Absolutely.
And then like that. All right, so any further?
Yes, Your Honor, I would like to make a record, if that's okay with Your Honor. First, we request immediate expedited discovery in this case. The people have had this case for about almost 3 weeks, and that's more than enough time to gather as much information as they can give to us, especially now that we have two proceedings that we have to answer to, one of them being death eligible. So we are requesting that we get immediate discovery of the New York City Police Department and FBI and federal and state documents. The second thing I want to make a record of, Your Honor, is I'm very concerned about my client's right to a fair trial in this case. He's being prejudiced by some statements that are being made by government officials. Like every other defendant, he is entitled to a presumption of innocence, but unfortunately, the way this has been handled so far, his rights are being violated. And as you know, Your Honor, there's a wealth of case law guaranteeing his right to a fair trial, but none of the safeguards have been put in place yet here. In fact, it's just the opposite of what's been happening. He's a young man, and he is being treated like a human ping pong ball between two warring jurisdictions here. These federal and state prosecutors are coordinating with one another, but at the expense of him. They have conflicting theories in their indictments, and they're literally treating him like he is like some sort of political fodder, like some sort of spectacle. He was on display for everyone to see in the biggest staged perp walk I've ever seen in my career. It was absolutely unnecessary. He's been cooperative with law enforcement. He had been in custody for over a week. He waived extradition. He was cooperative at all accounts. There was no reason for the NYPD and everybody to have these big assault rifles that frankly I had no idea was in their arsenal. And to have all of the press there, the media there, it was like perfectly choreographed. And what was the New York City mayor doing at this press conference, Your Honor? That just made it utterly political. And as Your Honor knows, under Lauro v. Charles, the Court of Appeals for the Second Circuit has held it to be clearly established that these staged perp walks to the media, unrelated to a legitimate law enforcement objective, is unconstitutional. And I submit there was zero law enforcement objective to do that sort of perp walk. There's absolutely no need for that whatsoever. And frankly, Your Honor, the mayor should know more than anyone of the presumption of innocence that he too is afforded when dealing with his own issues. And frankly, I submit that he was just trying to detract from those issues by making a spectacle of Mr. Mangione. And there are consequences to this. He has a right to a fair trial, and I just want to put on the record statements that the mayor made publicly about my client. Nothing saying alleged, for example, and he said, I wanted to send a strong message with the police commissioner that we're leading from the front. I'm not going to just allow him to come into our city. I wanted to look him in the eye and state, you carried out this terrorist act in my city, the city of New York that I love. And he wanted to show symbolism. Your Honor, he's not a symbol. He's somebody who is afforded the right to a fair trial. He's innocent until proven guilty. And the mayor was talking to jurors, future potential jurors that elected him. Those are the people that elected him that he is talking to and calling this man a terrorist. So, Your Honor, I just want to make a record of this and put everyone on notice that this has to stop. And my client is entitled to a fair trial and the presumption of innocence. And we're going to fight these charges, whether it's in the state or federal, to the fullest extent. Thank you, Your Honor.
All right, well, I know I have very little control.
All right, we've just been watching the arraignment as it's come into our newsroom here. Karen Agnifilo there for the defense, for the defendant there, Luigi Mangione and the prosecutor who we saw a little bit earlier. Let me bring back in our panel, John Miller, Joey Jackson with me. Joey, let's go over a little bit of what we heard. So she's asking for immediate discovery. She says that her client is being treated like a ping pong between the different courts, and that she has concerns about him getting a fair trial. And she pointed out as one reason that the perp walk that was, in her words, highly choreographed with lots of law enforcement, but also lots of press. Your reaction?
So in terms of immediate discovery, I think that's very important. We don't play hide the ball in New York State, nor should any state. The fact is that if there's information, if there's evidence, it should be turned over to the defendant and the counsel immediately so that it could be reviewed, evaluated, scrutinized, and so that he can begin to get a fair trial. On the issue of being a human ping pong ball, also a very important point to be made. I think what they were doing, not as a matter of justification, but observation, is that law enforcement was sending a message that, hey, if there is a crime that's committed, allegedly by you, by him, that we will go out, we will look for you, we will get you, we will bring you to justice. What that justice will be is an open question because, he deserves the presumption of innocence and certainly a fair trial. However, last point, and that is, this is a very unique circumstance. In this particular case, it looks like he has very much gravitated, and the public gravitated towards him. Usually as defense attorneys, you're concerned that your client gets a fair trial. You don't want pretrial publicity to take away detracting from that. Here, you have people who are saying he is a saint. He is a person who did something that we believe in that should be done. As crazy as it is for me to be saying that, this is what I'm listening to. This is what we're all listening to on social media. So to that extent, where you have the public that's really for him, it begs the question of what does a fair trial look like? Does it look like a trial that inures to the benefit of the prosecutors? Or does it look like a trial that inures to his benefit? And that, at this point, it seems that the defense has the upper hand with respect to public perception and people justifying and saying this murder was appropriate because of a healthcare industry that doesn't respect the public, that denies claims, and that is out of touch and out of step with what people are looking for, and that is adequate quality healthcare that they deserve, right? We all deserve, and so we'll see how it plays out.
I want you both to stand by because my understanding is that we have some sound from the prosecutor that we just got into our newsroom. Let's listen.
Voluminous, to say the least. I have never seen a case with such volume of evidence, aside from the issue of the quality of the evidence. And I suggest to counsel, because we have a discovery portal, but given how much evidence there is against this defendant, it would be smarter if counsel could provide us with a 2 terabyte external drive rather than rely on the crashing of the portal. With respect to statement and identification notice, we will be giving that notice within the next 15 days. We're preparing an ADF. We'll do our best to expedite discovery, but I'll say that with redactions and with the volume of it, we're hoping to do it as best we can this is not a usual case in terms of the thousands of hours of video tracking and the like, and the fact that we're not only responsible for discovery in this county, but in Altoona, where the arrest was made and where several officers were involved. And we're in touch with those people, and we're going to get everything counsel's entitled to. As to other issues, I think a 30-day adjournment to see where we're at, and to, of course, counsel's aware of the various notices. We have notices as well. I take it that the council will abide by the statutory limitations on their notices with respect to any notices they believe to be appropriate. As to council's record on the mayor, basically repeating what the mayor said, I don't know how that advances the ball. We will comply with our ethical obligations with respect to trying this defendant's guilt in this courtroom and this courtroom alone. Thank you.
All right, so,
All right, let's bring back our panel, but Joey, actually, I want you to respond to what we just heard there. I mean, on the one hand, it seems sort of logistical in terms of how they plan to physically hand over some of the discovery, some of the evidence. But on the other hand, I'm curious sort of what you think about his point about just how much evidence they have in their possession, especially you think about the notebook that was found in Mangione's possession with his own writings about the event, about the alleged event. I mean, what are your thoughts?
So what happens, Rahel, is that in New York State, you have to file a certificate of compliance. What that means in English is that the discovery laws were changed recently to provide all discovery. It's open file discovery. Everything you have in your arsenal, if you're a prosecutor, has to be presented. That could be challenging and that could take some time. It's not unique, right, where you can have the data transferred technologically, right, whether it's on a portal or any other type of device. But yes, in this instance, it'll be, as the prosecutor noted, voluminous. There's a lot there, but it should be turned over, and it should be turned over forthwith. And so, you know, once that happens, ultimately the state, once everything is provided, will file that certificate saying we're ready. The reason that's important, Rahel, is that there'll be various motions that are made. I'm assuming that the defense will make motions to preclude certain evidence from the jury on various grounds. The judge will have to make rulings on that, and it's only after that process occurs that the case can then go for trial. But that'll happen, I think, in the ensuing weeks, but I think the prosecutors may ask for extensions of time because there's so much information to gather and to provide.
Yeah, and John, I want to let you respond here. I mean, one, how rare is it for the prosecution to have, in their own words, this voluminous amount of evidence, at least for now, creating some sort of practical complications in terms of getting it over to the defense. But how rare is that for the prosecution to have that type of evidence heading into the trial?
Well, very rare. And, you know, there's a combination of factors here. The New York State discovery laws under the Criminal Justice Reform Act of 2020 is open file discovery. Prosecutors are always required to turn over evidence that may come up at trial, evidence that may be helpful to the defense, things that are exculpatory that may be helpful to their client. But in this case, they have to turn over everything that ever came into this case, every tip they got on another name, every other suspect they looked at. And the voluminous part is going to be all the hundreds of hours of thousands of hours of videotape that they collected in the process of this investigation. So it's a lot. The real trick here is going to be, are they going to be able to enforce that level of discovery on the federal government, which doesn't necessarily fall under this New York State requirement.
Interesting. Great to have you both, John Miller, Joey Jackson, and our thanks to Karis Xenel as well. Thank you.